Welcome to Immigration News by Ting Law. We have a lot to explain today about the USCIS policy alert issued out on July 15th about the discretion that they can apply when processing certain benefits, such as permanent resident status and also for employment authorization, also known as work permit. Now, this was in response to President Trump's proclamation issued on June 22nd this year, which is essentially an extension of his proclamation shutting down immigration temporarily, and that which was from April. So essentially, President Trump is pushing forward strongly with his "Make America Great Again" slogan, really by using the reasoning of the coronavirus outbreak, despite what he's saying contrary in national news. Now, what this policy alert does in a practical sense is that any guidance for these USCIS officers that was originally in they call the adjudicator's manual is now being inputted into the policy manual that they refer to when they adjudicate, also known as process these immigration benefits. Now understand, to you it may not matter what the manuals really mean, except in this situation, the Trump administration is really trying to press on that not only does the immigrant applicant have the burden to show that they're eligible for the actual benefit, but also that they meet this mysterious discretionary factors. The policy alert points out that the manual itself has a non-exhaustive list of discretionary factors. So they're trying to argue that if an officer wants to find a reason to deny you in what they call discretionary reasons, they will try to move forward with that. Of course, it doesn't say in plain language in the policy alert, but that's what I read between the lines. And if that happens, of course, you should file an appeal. You should take it up to every level until you are able to get that benefit. Of course, consult with your attorney, but this is really what the policy alert is trying to say, that try to break it open in terms of providing a catch-all phrase to deny your case if they really want to. Notwithstanding that, the policy manual in Chapter 8 does say that the immigration officer cannot arbitrarily deny your case. They cannot use their biases or assumptions in a way to deny your case, but that the immigration officer does have to focus on the specific facts and circumstances of your case. Now let's take a closer look at the policy manual and see what it says about discretionary factors or analysis. Now, the first thing to discuss in the policy manual is that now there's a chart in the policy manual, Chapter 8, that goes into detail about which applications, which benefits trigger the requirement of a discretionary factors. And it pretty much includes many of the applications. There's just a few that do not, and I'll start with that. That'd be the petition to classify an immigrant as a non-immigrant worker. So basically a temporary worker, like H-1B, for example. Also, the petition to classify a person as based on your family relationship. However, the petition is only the first step. The second step and final step, adjustment of status, does trigger the analysis of the discretionary factors. Now, I do want to assure you that there's a few applications that there is no requirement of discretionary factors. And that includes for application for naturalization, also known as U.S. citizenship. Some notable applications where it does trigger the discretionary factors are, for example, asylum, adjustment of status, temporary protected status, also known as TPS, employment authorization, so just any kind of work permit, waivers of inadmissibility, persons applying for refugee status, and also those applying for humanitarian parole, where they're here on a temporary basis. And also an application called advance permission to enter as a non-immigrant, which is typically filed by those who have been victims of crimes or victim of trafficking. The policy manual does specifically state that The USCIS officer does have to follow the confines of the law, of course, right? But at the same time, it does try to give some wiggle room for this officer, any officer, to deny a case. It does state that it does have to follow the case law, what we call precedent. Essentially, the Board of Immigration Appeals precedent says that the USCIS officer has to take a balancing act of the different facts, that if the negative facts outweighs the positive facts in terms of what they call the immigrant's undesirability to become a permanent resident in the United States within the social and humane considerations present on their behalf to determine whether that applicant being in the United States is in the best interests of the United States. So can you imagine how broad that is? That's pretty ridiculous to me. Because if I'm a USCIS officer, how can I know in a 15, 30-minute interview if you are undesirable to the United States? There's just too much to have to ask. And there's not a list of questions. They're gonna come up with random questions on their own. It's going to be a free for all. And I highly suggest you hire an attorney if you weren't thinking of doing that before. If you do hire someone, please do not hire a notario or notary. Those type of persons, they try to act like they're professionals, but at the end of the day, they don't know the law. They only know they can read the requirements. Certainly, it's on the websites. They can fill out the forms, but they can't analyze your case. They can't represent you. They don't have a law license. So please be careful. Consult with an immigration attorney that has a license. The manual also states that if there are negative factors, then the applicant has to offset that by showing unusual or even outstanding equities. Equities in the sense that they're positive factors outweighing the negative. The manual also states that once the officer determines that you are eligible, then they move on to the factors. And it gives an example for someone who's applying for adjustment of status. You have to be legally admitted into the US and inspected, and also that a visa is immediately available to you. So, for example, immediate relative type of relationship is a immigrant who's married to a US citizen. Now, if you're married to a US permanent resident, that is not considered an immediate relative. So if you have immediate relative relationship, then a visa is quote unquote immediately available to you, and that you are admissible to the U.S., meaning that there's no grounds, no reasons of inadmissibility. So the recent one that we've been talking about is a public charge rule. And for example, if you've been convicted of certain criminal convictions. So that's why another reason you should consult with an attorney to review that history. So I was discussing step one in terms of your eligibility. The manual does state for the officer to do their step one is fact finding. And so part of that is reviewing your immigration history, reviewing your family ties in the United States, reviewing your family ties in the United States, any serious medical conditions, any criminal history, other connections community, which is strange. I've never seen that before, or other information indicating a public safety or national security concern. Step two is for the officer to check whether you are eligible for the immigration benefit at all based on the requirements. And step three is going into discretionary analysis. So let's take a closer look at that. Now there's a long list of discretionary factors. We're not going to go through all of them today. I'm going to put a link in the description box with the USCIS website in reference to the Chapter 8 discretionary factors. But again, it goes into, for example, a criminal history, your community service beyond what has been imposed on you, if you've owned any property or any business in the United States, your history of employment, if you paid taxes. The policy manual even states that it looks at evidence regarding your respect for law and order, your intent to hold family responsibilities, and your good moral character. So this is quite strange because, if you're red or blue, there's a lot of news out there about President Trump. And if you're looking at that same requirement for him, he might not meet this requirement. Just saying. This is a concern because what kind of evidence are they going to look at to show that you're not following law and order? Now, we always look at criminal records, but what else could they determine? Could it be a social media post? Could it be school suspension when you're in high school? It doesn't state that. It's not a requirement to provide that, at least not right now. What it does say here is that they can look at affidavits from your family and friends, and also responsible community members. Now, one factor that I'm seriously concerned about for anyone who may have been found by a court, administrative court, when they're, let's say, high school, that they're a juvenile delinquent, because that can be used against you. So another good reason, always go to school, be present, be in attendance. But who would have thought that this would affect someone's immigration case in the future? Now, of course, the next ones are legitimate. They look at to see if there's any facts that determine you're trying to evade immigration law because you've married someone for fraudulent purposes, or if you've misrepresented to the government, you lied to the government. Now, lying can also mean that you concealed information from the government. Essentially, you've omitted information from the application, for example. Now, they have a catch-all phrase, of course, that says other indicators that go towards the applicant's character. And it also states that this is a non-exhaustive list. So that means that if something else comes up that doesn't necessarily fit this list of factors, they can use it against you. So again, I want to reiterate, please consult with an immigration attorney who is licensed. Even if you hire someone in Texas, but their license is from California, that's okay, because immigration is federal law. But please hire someone who's focused on this and ask them these type of questions if they even know about the discretionary factors, because every analysis step can make or break your case. So please be truthful to your attorney, even if it's in a consultation, so they can give you the proper advice. Otherwise, if you omit something or you don't say something, even if you don't think it would affect your case, you need to mention it. So to wrap up this episode today, essentially USCIS officers who interview you can deny your case based on a totality of factors. It may not necessarily be one negative factor. It could be several different negative factors that ultimately forces a immigration officer to deny your case. And even if an immigration officer gives you the wink, gives you the thumbs up that your case is good to go, don't get your hopes up, because they still can submit it to their supervisor for final review. We want to answer a question that one y'all commented about what's truthful out there in the news regarding if the green card or work permits have been stopped. Now, essentially, it was stopped at some point in June this year, just 2 months ago, because of there was information that we received that from the USCIS Ombudsman Office that they're looking for a different contractor to produce these cards. And combined with the factor that there was an anticipation of a furlough, but now there's no longer a furlough, it's been postponed until the end of August. But once that they get those things in order, they will start producing those cards. I'm sure it's in process already, but I wouldn't be too worried in terms of that they're stopping completely. I have heard from other attorneys that the work permits have been slow to be delivered to them, but that doesn't mean the work permit has not been created. Essentially, they've been already mailed out by USCIS, but USPS, the Postal Service, has its own issues, which we'll talk about in a separate video in our sister channel, Lawyer Up. So there's a lot going on in the government, not just with immigration, but somehow they're intertwined, right? I've had some cards being delayed as well by the mail system, not necessarily because of the production phase, but we eventually received it. But to be honest, it was a pain, right? We want to make sure our clients receive their card. We've worked so hard and so long because of the government delays in general that we want to make sure our clients receive their benefit, their card. If you are experiencing delays with your card production, please leave a comment. Let us know when you receive the approval date on your immigration benefit. We'd like our audience to get an idea of how long these delays are taking, especially with the external party of the USPS. We have a separate episode about the situation in regards to the stimulus check update and also how that impacts the furlough. So click up there for that. If you gain value out of this episode, please hit the like button and subscribe below if you haven't already. We really appreciate your comments, and we'll talk to you soon. Thank you. Have a good day.